Now, I will request Mr. Anil B. Divan, President of the Bar Association of India, under whom I have served for 4 years as Honorary General Secretary, and I think this has been the biggest privilege of my life. I could not find a person with better moral convictions, rectitude, to serve under. I welcome our Attorney General, Mr. Mukul Rohatgi. Kindly give a big hand to him. So, since Mr. Mukul Rohatgi has already graced the convention with his presence, I will, in the order of I think Mr. Divan should speak. Thank you.
Honorable Chief Justice of India, Shri R.M. LODHA, Justice Deepak Mishra of the Supreme Court, Justice Adarsh Goyal of the Supreme Court, Justice Lalit of the Supreme Court, you're all welcome. Attorney General Mukul Rohatgi, our guest from Sri Lanka, President of the Sri Lanka Bar Association, Mr. Upul Jayasuriya, my colleagues, K. N. Bhat, Vice President, Prashant Kumar, Honorary General Secretary, but more importantly, he is now President-Elect of LODHA. Priya Hingorani, Treasurer, Bar Association of India, distinguished members of the audience, sisters and brothers in the profession, law students, ladies and gentlemen. It's a pleasure and a privilege to welcome the Chief Justice of India, who has very kindly agreed to inaugurate this function. As Prashant Kumar already told you, the first one, this is the third one. The first one was inaugurated by Justice J.S. Verma, the last year by Justice Sathashivam, and now we have the Chief Justice of India who has kindly agreed to inaugurate this function. Now, Justice LODHA took office only in April 2014. But within that short span, he has bestowed great luster and very high visibility to that office. Above all, his judgments, his speeches, and his interventions have lent high moral authority and vigorous leadership to the judiciary. I think this is a matter of admiration, both for the common lawyer as well as the common citizen. The presence of Upul Jayasuriya, who was a councillor in Lawasia many years ago, jogs my memory. Exactly 21 years ago, that is 13th of December, 1993, we had the 13th LODHA conference in Colombo. It was inaugurated by the President of Sri Lanka, D.B. Vijayatunge, in the presence of the Prime Minister Ranil Wickremesinghe and other dignitaries. I had the distinction as LODHA President of welcoming these guests. So I think Upul Jayasuriya has travelled far and wide in the Lankan bar. From a councillor of LODHA, now he is the President of the Sri Lanka Bar Association, and I think we welcome him. Friends, you will have a lot of sessions on the rule of law, etc. But what is the rule of law? The rule of law and the independence of the judiciary is important because power, enormous power, always leads to abuse. And in our constitution, there are many checks and balances, but the principal ones are the judiciary with the power of judicial review and enforcement of fundamental rights. Then you have a free, vigorous, and very inquisitive media. That's a great check on abuse of power. Then you have the Comptroller and Auditor General of India, the CAG, who audits the financial accounts, not only of government, but all public sector units. You have also the Election Commission, headed by the Chief Election Commission, which ensures free and fair elections. So these are the great bulwarks. These are the great institutions constitutionally mandated to act as checks and balances on absolute power. Yesterday, we saw an interview by the former CAG, Vinod Rai. He is reported to have said, and I quote, "The story of the country's auditor is worth narrating, since it described the misguided belief that the underlying objective of all action is to remain in power, the nation and its people be damned," unquote. He further went on to say, "The coal mining saga is a remarkable study of people in power when provided the mantle to lead faltered the moment a challenge arose," unquote. In fact, how have these checks and balances unfolded? The CAG report triggered public interest litigation in the courts, which led to the setting aside of the spectrum licenses. And what happened? It was re-auction. On re-auction, what happened? On re-auction, about 40,000 crores went into the public treasury. So you see, the report of the CAG, a public interest litigation, and a judicial determination enriched the public exchequer by 40,000 crores. The same thing, a public interest litigation has now led to the declaration that the coal allocations are illegal. Friends, it's our duty as lawyers to uphold the rule of law and give every support to these constitutional functionaries and these constitutional entities. All political parties all over the world, it's not only in India, will endeavor to attack and undermine these checks and balances. But the legal profession must stand by and support them when faced with attacks to undermine them. Now, there are many shortcomings, there are many drawbacks in the functioning of all these institutions, whether it's the judiciary or the election commission or the CAG, but they have to be reformed, and reformed in a manner which does not mean undermining them or the fact that they should become subservient either to the executive, political, bureaucratic, or even to the legislature. So there are drawbacks. You have to address them, but not at the cost of their being subservient to the executive power. I quote the president of the American Bar Association, who said many years back in his annual speech, and I quote, "If respect for the courts and for their judicial process is gone or steadily weakened, no law can save us as a society. Lawyers, whatever their views on controversial decisions, must inspire respect for the judiciary. I repeat, lawyers, whatever their views on controversial decisions, must inspire respect for the judiciary. Unquote. Friends, we have fought as lawyers, young lawyers, many battles. The bar fought the battle when the first super session took place in April 1973, when 3 senior-most judges of the Supreme Court were superseded for the 4th one, who had decided the major cases in favor of government. So that was the first battle joined. Then, during the emergency, many of us came solely, myself, from Bombay to argue for détenus in the habeas corpus case. Later, after the emergency, the famous case of the circular issued by the law minister was challenged. And in those days, many lawyers came from all over India. I remember Sirvai and K.S. Cooper represented the Bombay Bar Association, and they spent over a month and a half before the bench of Chief Justice Bhagwati, all in a pro bono honorary capacity. So friends, this battle for supporting the rule of law, protecting it, is a never-ending battle. And it has to be based on the bedrock of human rights. And I conclude by quoting the famous words of the great wartime Prime Minister Winston Churchill, who made a very short speech, a one-line speech. And he said, never give up. Never, never give up. Never, never, never give up. Thanks.
Friends, as I had said, that we have to make an effort to prove Kafka wrong, that a revolution should not sink into a stinking new bureaucracy. And that is where our next speaker, Attorney General, has brought a kind of refreshingness to the Office of Attorney General by taking a resolve to weed out litigation from the government which leads to nowhere, which is frivolous, by examining himself most of the SLPs along with his team of law officers which are to be filed, and burdening the court only when there is a case fit to proceed or the government's interest suffers in a manner that without recourse there will be a great damage. With this step itself, the docket of the Supreme Court will be unclogged somewhat. And it is this kind of approach that we look forward to in every aspect of governance, so that we curtail the waste of time, money, and resources. So I welcome Mr. Mukul Rohatgi, but with a short apology that perhaps there was some communication gap. And I will ask him to say a few words to us. Thank you.
My Lord the Chief Justice, judges of the Supreme Court, judges of the High Court, retired judges, dignitaries on the dais, senior lawyers and friends. Firstly, I apologize for being late. There was some mix-up, as Prashant mentioned. That's why I'm dressed rather casually, as opposed to people wearing suits and ties. But anyway, better late than never. Obviously, rule of law is the spine of democracy. And with that go a multitude, there are multitudinous factors. An independent judiciary, right of judicial review, enforcement of fundamental rights, and respect by every organ under the Constitution of its own limits, whether it's the executive, whether parliament, whether court. And it's a healthy compartmentalization with the ultimate power of the court to strike down a law made by parliament. As far as rule of law is concerned, and Prashant made a point, I personally am of the view that unless litigation is reduced drastically, which also has many inputs, the rule of law does suffer because expeditious justice becomes a distant reality. And obviously the government instrumentalities have a major role. After I took over, I found that out of about 80 to 90 cases which the central government has in the Supreme Court every Monday and Friday, I found that about 25% relate to direct and indirect taxes. The others are much lesser. Then I set about trying to find out. I spoke to Chairman CBDT, etc., etc. The problem seems to be a mindset in the bureaucracy that everything must be left ultimately to the court. All the files that I get, whether an appeal should be filed or not, will say that this is the point, this is the view, but finally it will say, as Mr. Sorabji knows well, finally the last line will be, it is left to the law officer or to the government to file or not to file. So the idea is you pass the buck, you spend pages and pages, but the last line will be, let the call be taken by the law officer. So I have to take a call, and my team also takes a call in trying to refuse as many cases as we can in which we feel that there is nothing involved, there is no precedent involved, etc., etc. So if we are able to set right some part of this system, obviously the rule of law will get strengthened. That's one. Another small point which I wanted to make, which kind of deviates from this constitutional issue, is also that we lawyers must also train our youngsters. Rule of law also includes deference to the court, decorum in the court, a procedural manner of going about things according to some procedure, some norms. Therefore, our youngsters who come into the profession must be told, must be educated that there were high standards set by lawyers, starting from, let's say, great lawyers like Bhulabhai Desai, coming down to Daftari, Setalwad, coming down to many others like Mr. Palkiwala, and presently our senior lawyers like Mr. Nariman, Mr. Sorabji and others. Those were the traditions which I think must be instilled, because unless they are instilled and the traditions are kept high, you will find that the institution as a whole will suffer if we don't have this proper atmosphere. And I must say before ending that I am very grateful as a lawyer, and I am not talking as an Attorney General, to my Lord the Chief Justice for what he did in bringing 2 appointments from the bar to the Supreme Court. And I think this singular act, in my view, as a lawyer, has the most significance maybe in the last 10 years or 15 years, because the last judge was Justice Hegde, who also retired many, many years ago. And I wish the future Chief Justices will keep up this tradition, because otherwise lawyers practicing the Supreme Court definitely suffer, even as appointment in the High Courts or the Supreme Court, because they are not before the High Courts, so the Chief Justices can't see them. They are in the Supreme Court, but they have been far and few. And I must say, my thanks and my regards to the Chief Justice, who will always be remembered for this singular act, apart from many other things he may have done. But in my heart, this is the dearest to me and to the profession. Thank you.
While inviting our chief guest, Honorable the Chief Justice of India, I must say that already what Mr. Divan and Mr. Rohatgi has described him, it is difficult for me to add anything more. But at the same time, I want to highlight a third point of view, that is of the young lawyers. From his very early days in Rajasthan or Bombay High Court and even here in Supreme Court, Chief Justice LODHA has tried his best to encourage young lawyers, given them a very patient hearing and encouraged them, even when they are slightly less prepared, to go on with the brief with an assurance that if there is some merit in your case, I will help you, I will render justice. That kind of attitude makes the life and the professional career of a young lawyer. Lordship, without ado, I invite you to deliver the inaugural address. Thank you.
Brother Judges, Mr. Mukul Rohatgi, Attorney General, Mr. Anil Divan, Mr. K N Bhat, Ms. Priya Hingurani, Mr. Prashant Kumar, distinguished foreign dignitaries, distinguished senior advocates, distinguished advocates, my young friends, ladies and gentlemen. This summer, I had an occasion to attend 2 international conferences. One at Petersburg, where about 75 countries participated, about 30-40 chief justices of different countries were there, and about 25 ministers of justices of different countries, and about 3,500 delegates around the world attended that conference, which was held in Russia's one of the best theaters, Mariinsky Theater. The subject was rule of law and quick takeaways from different legal systems. The organizers extended a privilege upon me to address the plenary session with the Prime Minister of Russia, Mr. Medvedev, Minister of Justice of Argentina, and Chairman of International Red Cross, Geneva. We were the 4 speakers. I started my speech by saying, India is a very strong